Okay, good morning, everybody. We're going to get started in just a second. We're going to see if a couple more folks are going to log on here. We got people logging in pretty rapidly. So give me 1 minute and we'll get going. Okay, good morning, everybody, and welcome to the Burr & Foreman Morning Show. I'm Brandon Smithini. I'm the chair of the Labor and Employment Practice Group here at Burr & Foreman, and I really appreciate you guys who have decided to sit through an hour of wage and hour discussions. I know it's not the most lively way to get started on a Thursday morning, but we're happy to have you here, and we appreciate all of the folks who have decided to attend this morning. Before we get started, just a couple of housekeeping items. One is that if you have any questions during the presentation, rather than using the chat feature, send those through the Q&A, and I'll have access to those, and we'll try to get to them. Either as we go through the presentation, I'll take a quick look and see what folks are asking, and then once we get to the end of the presentation, I'll address those. So let's just go ahead and dive right in. The summer's almost over. I'm flying solo on your computer screen this morning, and nobody's monitoring me but the marketing team. So we're gonna have a little fun today, or at least we're gonna try to. I am. I can't see you. I guess I'll never know whether you did or not, but that's the goal. So I let my 13-year-old daughter, my youngest, watch Stranger Things this summer. Didn't realize it was gonna be quite so violent. Probably should have. Maybe not the greatest parenting decision I've ever made, but also nowhere near the worst. But one of the things it did do was lead to this happy outcome for me. She's now in an 80s new wave music phase, which is somebody who grew up in that was in high school during that era. That's kind of exactly my sweet spot. So because my daughter only has one approach, probably like your kids, and that's full-time obsession with whatever she's interested in all the time, I've been hearing nothing but 80s new wave lyrics in my head for the past few months. And so what I've decided we're going to do this morning is explore how these 80s song titles relate to wage and hour law in the 21st century. You can see the obvious connection there. It's pretty evident to anybody that thinks about it. And and so I think this will be a fun way to explore the changes in wage and hour law as we head into 2022. And one of the great things about this presentation is you can turn this PowerPoint into an epic playlist for cocktails on the patio when we get tonight after we're done. So I'm going to start with a song that, from the show that actually triggered my daughter's interest, and it's mainly because I believe this title aptly describes what every HR professional has been going through for the past couple years, since about March 2020, I guess. I think you know what I'm referencing, and like you, I'm sure you're hoping that we're going to have a downhill coming at some point. We're not going to be running up the hill the whole time. But the reality is, I can't predict when that's going to be, because frankly, nothing's like it was before. So let's just dive right into the agenda. In general, my plan is to talk this morning about why wage and hour law remains so important and how it continues to evolve as a result of a lot of the changes that we've seen in society over the past few years. But just because that's what wage and hour law does, it evolves over time. It's the sort of thing that we're seeing constant changes to, and you HR professionals who are interested enough to be here with us this morning already know that. But really, I mean, you see on this slide the thing that you're facing in reality. The labor markets are in absolute turmoil. People are having a hard time finding folks to come work. They're having a really hard time keeping them. Retention is harder than it's ever been. Candidates are not responding to traditional incentives. The things that used to attract employees and keep them with our companies, things like paying them well and providing excellent benefits, those don't necessarily work in the same way that they used to attract and retain these candidates. And so we've developed some new models and some new ways to attract people that are working in some instances, but also create a lot of problems for us in the human resources world that have to deal with the consequences of the decisions that are made to put people into these new work models. So, all of that is background for this is all about to change again. Employment lawyers like me who work a lot in the wage and hour field, we're recognizing that the climate's about to change again. We're about to see all kinds of new issues that are going to turn it on its head one more time. And so this presentation, I want to talk about what those changes look like and how we can, as human resources professionals, as lawyers, deal with those changes as they develop. But things like, the recession that everybody keeps anticipating. Is it going to happen? Is it not going to happen? What we do know is that there's enough uncertainty out there that it's causing people to make decisions that are going to change our lives. And those decisions are formulating in things like rulemaking, new legislation that's coming, all of those things that I want to keep you guys up to date about and give you the opportunity to ask some questions and let's talk through some of it. Hopefully we will address a few of the questions that you sent in advance of the presentation during it. I've incorporated those into the discussion. But if you have some, don't be afraid to ask. I would love to address any questions that you have about the things that we discussed this morning. So let's dive into really the most immediate trending issues that are going to apply to this narrow topic that we've developed today. A lot of workplaces look a lot emptier than they did 2 years ago. And you guys know that. I have one large client that's completely abandoned all its physical space. Employees are just gone. And that doesn't mean that the work has diminished or even that productivity is down. For a lot of you, the work has increased. As you've had the flexibility to work from home, to work remotely, the work that you do has grown exponentially as a result. And that's the reality of the modern workplace, I think, in one sense. But the reality for us that have to monitor these issues is that a lot of the folks just aren't here. We don't have the ability to track them in the way that we tracked them before. And, personally, I've experienced it firsthand. My wife's a bank lawyer. And while she works from home most days, she's far busier than she's ever been before. She feels less productive now when she has to drive downtown, find a spot in the parking deck, navigate the distance to the office, only to log into the same video calls that she could have made from, her fully equipped home office. So, I get it. I've seen how the remote workplace can be beneficial to both parties. And it makes some sense for some people and for some businesses. And a lot of businesses have used it as a tool to find more talent, to be able to open their opportunities for talent up over a wider geographical footprint, to find people that can work for the company that they couldn't have had access to before. Others have used it to retain employees who, maybe had to move or just couldn't make the trek into the office in the same way that they could before. So all of that is great and wonderful. For some people and for some businesses, it works fantastic. But for those of you who have had to manage it, I know that you realize it's nothing but headaches for HR. But I think we all have to understand and agree that it's certainly here to stay in some form or fashion. The bullets on this slide reflect the data and anecdotal evidence. I mean, everybody agrees that remote work is going to be the remnant from the pandemic that is going to leave the most indelible imprint on the American workplace. I don't think there's really any dispute about that. As we went through all that we went through for the last couple of years, we discovered that this is possible. This is feasible for some types of employees in some workplaces. And regardless of industry, almost every business that either has or, either already has or will find itself facing decisions related to remote work. But the lessons that we learn from managing the remote workplace are the kinds of lessons that you can incorporate into your HR management, even if you don't have a high number of remote employees, because the lessons that we're learning are things like how to paper up policy, procedure, how to prepare for the fact that we're not going to see people as much as we were before. The auditing process. We're going to talk a lot about these tools that we can use that apply equally to remote work and are important, really critical if we're going to have employees that we don't see on a day-to-day basis, but also apply and are valuable tools that we can incorporate when we do have a workforce that's here and physically present all the time. So I don't want you to think, if you don't have a lot of remote workers, that the next few minutes are completely useless to you, because I think that they all apply. All these lessons apply to everyone who has to manage employees on a daily basis. But just to talk about some of the legal issues that the remote work could involve, these, in some instances are beyond the scope of what I want to dive into today. But when you think about the ADA implications, are we, by establishing a remote workplace, are we saying that you can perform the essential functions of the job remotely, and presence at work is no longer really a critical essential function? We have to be careful not to establish that as a permanent thing if we don't intend for it to be. Things like FMLA eligibility, the discrimination claims that we've already seen. As someone who defends discrimination claims on a regular basis, I've already had 6, 8, 10 cases that are asserting that someone was not provided the opportunity to work remotely when other people were, and to utilize that as a term and condition of employment upon which a discrimination claim can be based. And so we have to think about all those issues. But our agenda here today is going to start with how the impact on how employees track and pay remote employees, and also the way that relates to traditional employment models when we aren't managing a remote workplace. It's hard enough to manage a workplace where we see everybody every day. But like in the Breakfast Club, when detention ended and they all went their separate ways, and that famous Simple Minds montage at the end, when employees leave the office to work in a place that we can't monitor, it's easy to forget they ever existed at all. And so, the hope is that we can ensure everyone is actually doing their jobs all the time. But that's a pipe dream. It's a pipe dream when we have everybody at work every day in reality. I mean, we know that. Employees that are sitting on Facebook, employees that are, taking smoke breaks that are far too long. I mean, all these things are issues that we've dealt with over time, from the beginning. But now, when we don't see them at all, when we know that they're at home, there's no hope, when they're at their kitchen table, that we're going to keep them focused on their work all the time, right? So what are the legal implications of that? And then again, how does that relate to the traditional models where employees are sitting at a cubicle or out on the floor every day? What lessons can we learn from that? And the first and most immediate concern is always going to be off the clock work, right? One of the challenges of a remote workplace, or even the new technology that enables employees to work remotely, even if they are primarily coming to the office every day, is that our non-exempt employees are not capturing all the time, or that they are working and are simply not reporting their time, and that can build up over a period and create some significant exposure for us. So the most immediate concern is to focus on whether or not employees are performing work off the clock and what we can do about that. One question that we received in advance asked about non-exempt employees that are paid on a salary basis. So, you got a non-exempt employee, but you pay them, the same amount every work. The expectation is they're going to work the same number of hours every week. And, but they're receiving text messages, emails, calls to seek their input on an issue. Do we have to compensate for that? And while not identical, this is really in the nature of remote work. It's work that's being done away from the traditional places that the work is performed. So, the answer to this question, I think, is instructive, and it's important for all of us. Set aside the fact that they're paid on a salary basis, because that doesn't matter, right? The question is whether they're non-exempt. And if so, they have to be paid for the time they work. Now, do we have to pay them for every single second or minute that they perform work? Do we have to track a 30-second phone call? Do we have to track a 1-minute, email? And all of that is really just a judgment call, because there's a concept called de minimis under the Fair Labor Standards Act, where if the time that the work is performed is so minimal that it really amounts to nothing in the grand scheme of things, it's not necessary that time is recorded and paid. But what we're talking about here really genuinely is the 15-second, the 30-second phone call. We're not talking about where an employee spends 15, 20 minutes on the phone answering questions or sends a substantive email responding to a question that a supervisor had. If that's happening, we need to establish a way to track that, because we have to see, going back to the slide now, employers must pay even unauthorized remote or in-office work if they have actual or constructive knowledge that it was performed. And so if an employee is responding to a question, then we obviously have actual knowledge that they're doing the work. But in the remote context, in the, where an employee is working traditionally in the office, but sometimes is working away from the office, if it's a job that the employee performs every week, if we know that that's the kind of thing they do for this company and they record that time and turn it in and expect to be paid for it, if we have constructive knowledge that that's what they do and that they generally perform that work, then we're going to have to pay for it. Courts will ask, could you have acquired the knowledge the work was performed through reasonable diligence, right? Through proper monitoring from a supervisor, should we have known that this work was being performed? And if so, we have to pay for it. And we're going to talk about some tools to try to prevent that. But ultimately, what the Department of Labor says to us as human resources professionals is that the employer bears the burden to prevent the work that it doesn't want or need performed. HR professionals and employment lawyers respond, okay, yeah, sure, you try to do it. It's a lot easier said than done. And while I recognize that, the ultimate lesson here is that if an employee is recording time, then we're probably going to want to pay that employee for the time that they record. If we have skepticism, if we believe that they may have worked in an unauthorized manner, if they were doing, if they were inflating the time that they worked, we need to deal with that from a disciplinary standpoint. And we're going to talk a little bit about how to do that. But the reality is that the inference that's going to exist is that they did have the authority to do that work, that we suffered it. If it was for the benefit of the organization and we can't demonstrate that it wasn't, and we can't demonstrate that they didn't do it, then we want to pay for it. And then we want to deal with the consequences of that later on. I think about, when we're talking about remote work, to me, it reminds me of like when Bo Jackson was running wild during this same 80s era. You can't stop him. You can only hope to contain him. And that's what we're really trying to do here. We're just trying to get our arms around and contain the real big problems while not necessarily worrying on a day-to-day basis about the small issues that don't amount to much. And so, the song title I chose for this slide, clearly it references Elvis Costello's masterpiece from the early 80s about timekeeping. Obviously, I don't know if you remember all the lyrics, but it was about timekeeping documentation. We wouldn't be allowing these folks to work from home if we didn't, if we actually expected them to devote every second that they're clocked in to actual work, because that's not realistic and we know that. So we wouldn't be letting them do it if we thought that it was going to happen, in this precise exact way. So it really does no good, I don't think, to allow ourselves or our frontline managers to become overly militant about this issue. The question that we have to ask ourselves is, are we getting the production that we expect for the hourly work and the wages we provide? And if the answer to that question is yes, then in my view, it's important to transition from like a dogged adherence to the time clock to what's really more realistic, which is effective compliance with our policies and procedures. And, if we're not getting that compliance with our policies and procedures, then the solution is progressive discipline, as I mentioned before. And that to me is what's important for remote work. And that's what's important even for work done in the traditional workspace where we don't have the access or, the realistic ability to monitor what the employee is doing every second of the day. And I'm distinguishing between things like, where an employee's sitting at their cube and we don't know if they're actually doing their job or if they're playing some game on their computer versus, an employee on an assembly line where if they're not doing their job, things start backing up and the line has to go down because they're not doing their job. So we got to, recognize the differences between those two types of workers. But, in terms of what we want to accomplish as human resources professionals to ensure that we are monitoring remote work that's done away from the traditional workplace properly, we have to set expectations through our written policies and procedures. If you don't have a timekeeping policy you need one. And, I would say 15 years ago, it wasn't as critical, but with the ability to work in multiple places and in multiple different ways, we have to let our employees know exactly what we expect and what the consequences are going to be for failure to comply with those expectations. Establish rules and protocols for timekeeping and reporting. Require strict attention to these processes. So what that means is, look, if you are expecting your employees to report their time or to track their time in a certain way, tell them in writing, and tell them what's going to happen if they don't do it. But more importantly, we've got to make sure our managers know the nuances of these rules and what we're really focusing on, what's really critical here. If we recognize that it's not realistic on a day-to-day basis for our managers to know whether an employee spent 15 minutes on Instagram rather than doing their job, and really we're not that concerned because what we're looking for is the ultimate production. We want to make sure they understand that and that they're not working against us, the HR team, by discouraging employees from reporting the time that they're working. Because we don't want to be in a position in litigation where we have a bunch of emails that makes it appear that the manager is telling the employee don't report everything. Now it's okay to say don't record time that you're not actually working, but those emails often lack the nuance that would be necessary. Text messages, emails that are going to be retained and can potentially be evidence in litigation. We want to make sure that our managers understand what we're trying to accomplish here, that they know the rules, they know the protocols, and what's the overall philosophy of the company with respect to time that's worked away from the traditional workplace. Require overtime approval in advance, unless you have complete trust in the employee. Don't give them the ability to say, I worked 70 hours this week when you can't demonstrate that they didn't. Make sure that the employee is required to get that approval in advance so that they have an opportunity and an obligation to articulate clearly why they need to work that overtime. There may be lots of good reasons, that's not what I'm here to suggest, but we want to make sure that our supervisors know that work's going to be done and why before we empower the employee to do it and to turn in a timesheet that's going to double their pay for the work week. And then most importantly, I think, is provide a clear complaint procedure for employees to report issues. We want, as HR, and it's just like every other, topic that we deal with, we want to make sure that our employees have an avenue to address concerns so that at the end, when there's a problem that we've had to resolve, they can't say, I didn't know who to tell. I didn't know what to do about it. We can show clearly and in writing, this is what you do, this is who you tell, and you ought to know. And so, when we talk about the ways that we can prepare ourselves for these problems, this is the most critical slide, I think. It's about the policies and procedures and the expectations that we create and the important strict adherence that we have to those rules. So to finish up real quickly on remote work issues, it's important, for everybody to recognize we could and have devoted entire webinars to timekeeping. But as Boy George once sang, time won't give me time. Of course, nobody knew what the hell that meant because it's just a bunch of nonsense words. But it didn't slow Boy George down, because then he's saying, time is like a clock in my heart, and we're all like, yeah, George, we're still not following you. Don't know what that means. But regardless, did you honestly think that there was going to be a song title that was just time and I wasn't going to use it in this presentation? Of course not. So we're going to set aside the fact that the entire song makes no sense at all and just dive right into the final issues related to remote work that I wanted to talk about. The only real issue for an exempt employee is the exempt status. We're not necessarily worried about off the clock, how to report it, all those things. What we're worried about is that they still meet the test even from a remote work site. And this, again, applies even in the traditional model, which we're going to talk about in a second. We need to constantly be asking ourselves, do our exempt employees meet the exemption? Because those things change over time. And especially for remote workers, for example, if they're treated as an executive exempt position, they supervise the work of 2 or more people, they have discretion and independent judgment with respect to hiring, firing, compensation, things like that. That's great. But that's a little bit harder to do when you're working remotely, obviously. And I think that people that are evaluating those decisions are going to view them with a little bit more skepticism. So we want to make sure that we are evaluating their job duties and the actual, real job duties that they're performing when they are working remotely, and we are classifying them as exempt. And then let's clean it all up. How do my employees report unscheduled work when I'm not at the office? What's the mechanism for that? Is it effective? Is it efficient? Do I document it well? Do I have the ability to go back and ensure that I can prove that they reported the time that they worked? Do my policies and procedures sufficiently address meal and rest periods? That's a really hot trending topic in wage and hour law, is an argument that employees are docked for their time for meal and rest periods, but they actually work through them. And it's developed into a number of class and collective actions around the country. So do we sufficiently address how employees should take and record meal and rest periods? What about login time? That's another one that has historically been a litigated issue and has really only grown over time. And that is, it takes me 5-10 minutes to boot up my computer before I can even log in to, essentially clock in for the day. And the same amount of time to close down and to log out. Are we tracking that time? Are we recording it? Do we determine that it is compensable time? And so all these issues have to be factored in to whatever mechanism your employees are using, particularly with remote work, but also the traditional model. Most of the cases that I've handled like this have involved employees that are coming to the office to do the work, or opening up a store, or having to get a machine ready before the day begins, before they have the ability to clock in. And so we need to think about those issues. And then, as always, as I mentioned before, we have to establish those clear expectations about the mechanism. Do employees know how to use it? If we conducted an audit and an employee said, well, this is what I do, but I don't know really how you want it. But you believe that there is a mechanism that's clear and that the employees are failing to utilize, then we want to make sure those expectations are met. Obviously, consistent enforcement, that's the motto of employment law in general, is to make sure that we treat everybody the same. And this is an area where enforcement consistency can be more complicated. It is not as easy to consistently enforce all these rules, again, because people aren't always here. Have we trained our supervisors? Another one that's just throughout all of employment law, the question is, do the frontline people that are actually on a day-to-day basis communicating with these workers know what our rules are? Do they know what the law is? Do they know what their job is? What are your expectations for them for reporting issues to you? Do they understand them? Do they know what to do? And then again, as I said before, always responding to complaints, making sure that we have the ability to demonstrate our good corporate citizenship to a judge or an arbitrator or a jury that's evaluating that at some point in the future. And, as I always remind people in these presentations, remember that if you're ever sitting in front of a jury, you're trying to persuade 12 people that know nothing about you, that you're a legitimate, honest person who has the employee's best interest at heart, and they don't know you. And so we've got to be able to show the ways in which we live that every day. So, as if all these challenges weren't significant enough, one critical development is that the Department of Labor has a renewed investigatory commitment. It's entirely possible that we're going to have more folks knocking on our doors than ever before, and they're all going to be coming with an agenda. Colin, hey, he refused to answer the door and said he'd only run and hide. You won't have that option. So the solution for you is to be prepared when they knock. We're going to have over 100 new investigators on the clock looking into workplaces around the country starting in 2022. Over 100 new investigators. We also have seen that there's going to be an increase in the agency lawyers. So what that means is, really sort of subtly important. The investigators can only do so much. It requires the agency lawyers to enforce the violations that they conclude exist based on their investigation. And a lot of times things have stalled, or they've been willing to settle or take the employer's word for it, largely because they just didn't have the resources to execute on the enforcement. And it's very likely that, based on this new hiring initiative and this, intent to be more dedicated to the investigatory process, that it's going to be more aggressive than ever. There's a stated intent to increase penalties for non-compliance beyond those that are currently available. And so what that means is, now if we had a wage and hour, investigation, if the Department of Labor audited and they came to a conclusion that we had violated, some portion of the Fair Labor Standards Act for, a number of employees, we would just pay them what they say we should have paid them, and that would be the end of it. And that's actually not much of a disincentive to violate the law in the first place. And I have to admit that there have been times where I've had employers who are engaged in very minor violations, and the answer is, well, you don't necessarily have to change it. I know it would be administratively burdensome, because if somebody comes in and audits, we'll just pay it and we'll move on. And that's a strategy that's been pretty effective. If the intent is to increase the penalties for noncompliance, then that's going to all change. If suddenly the failure to calculate some minor bonus into overtime for the period that would result in, an employee getting 10 extra bucks, if suddenly that becomes a $5,000 penalty per violation, then we have a different calculation to make. And so that's another thing that, as we see these policies and administrative philosophies develop, we're going to have to pay attention to. We need to be focused on the historically controversial and complicated issues, the ones that can create big exposure. Things like misclassification of employees as exempt or non-exempt. Things like using independent contractors that should probably be designated as employees, but we 1099 them. If you have a large number of those in your workplace, you need to pay attention and make sure that we're buttoned up, that we know that we're in compliance with those independent contractor rules. It's another topic where we could spend an entire hour talking about the changes to the independent contractor doctrine. There have been significant ones. And if you have independent contractors you utilize, you need to look into that. Call us, let us walk you through what some of those issues are. And then, joint employment. And we're going to talk a little bit more about that in a second, but the idea that we're the joint employer of a worker who perhaps is a temp, perhaps works for a contractor that's on site all the time, what impact does that have? And I can tell you that some of my biggest collective actions over the years have revolved around the idea that we were the joint employer of a group of employees. So we need to pay attention to that. And then, of course, finally, in preparation for these increased investigatory efforts is to identify any high-risk off-the-clock areas with large numbers of employees. One of the things that has been a pretty significant change in the procedures for a lot of employers during the pandemic has been, things like COVID screening and testing and questionnaires and things like that as people enter the workplace and exit the workplace. There have been, collective actions when, especially when a large number of employees spend 10 to 15 minutes in a security screening for COVID, should they be paid for that? We need to think about what our procedures are and whether or not what we do that is either a safety or security screening in advance presents any off-the-clock payment issues that the Department of Labor would be particularly interested in if they audit this. And that could lead to, significant exposure under the from a collective action or something like that. So again, this is something that I just want everyone to recognize as a developing issue in the wage and hour environment. There is going to be an increased effort to investigate, to audit, and to penalize employers who are engaged in violations. And all of us who are human resource professionals need to be prepared for it, because it's only us. It is, from experience that you're the only ones that can ensure the company's in compliance. Nobody else knows what to look for, and nobody else is even going to care about these issues until the Department of Labor investigators standing in the lobby looking for answers from you. And nobody else is going to know those answers. And then all your leaders are going to be looking at you, wanting to know why you didn't see it coming, right? We all know how this game's played. So for the folks that are interested enough to even attend this seminar, it's critical that we protect ourselves. And, I'm here to represent my clients. I'm interested in the corporate entity first because that's my job, but I also care about you guys and making sure that you look good and making sure that the job that you do is made easier and that you're protected from these kinds of questions over time. That I'm giving you the tools that help you sort of, cover your own ass when it comes to these kinds of issues. And so what do you need to do? I mean, to me, it depends on the environment. Obviously, you have to have the support of your leadership, but we have to ask questions. We have to demand answers. You can't solve a problem that you don't know exists. So you have to insist on that information that you need so that you can audit and adjust. And what that means is, to me, and I don't see this enough, to be candid, I don't see my clients doing this enough. I try to encourage it. I think it's probably because it's burdensome and expensive, and I get it. But, I've just been involved in so many cases that could have been easily resolved on the front end if we had just conducted regular audits. The problem was we didn't know what was happening out there. We thought we knew, but we didn't know. And the reason we didn't know is because we weren't demanding answers to questions about how the job had changed over time. Re-examining the exemptions, editing our job descriptions to account for the changes in duties. We know it happens. I mean, we change job descriptions all the time because jobs evolve. And we need to be changing those when they occur because a job has perhaps moved from exempt to non-exempt or vice versa. How do these audits enable us to know exactly where an employee is and how they should be paid? Are we paying them improperly based on the actual duties that they are performing? In my view, it's important to involve third parties, and obviously this is a little bit self-interested because it's one of the things I do. But I think it's important to have a third party to help you consider those classifications with objective eyes. Somebody that can provide credibility to your own recommendations. Because, they hear it from you all the time. It's important maybe that they hear it from other people as well, that this job has changed. This is not the job anymore. And this is how we need to modify it so that we're doing the right things. We've got to review all contractor and temp relationships and contracts for indemnity and for joint employment language. And particularly for temps, I mean, for those of you, I think a lot of companies, and I know probably not you that are on this call, but a lot of leaders think that when I have temps, when I've hired somebody to provide employees to me, well, they're paying them. They're not my employee, they're paying them. It's not my job. I don't have to track it. I don't have to keep up with it. And I don't have to worry about it. The reality is in almost every temp situation where we're hiring employees to work side by side with our own workers, we're their joint employer. And what that means is that we're going to have the same exposure that they do. If you've heard me speak before, I always remind my clients that the defense, it's not my responsibility. The temp agency handles the time records and makes sure that they're paid properly. That's about as effective as, but officer, everybody else was speeding too. Doesn't matter, right? We're their joint employer, and we are going to be held responsible and accountable for wage and hour violations, even if we have a contract with some temp agency that says they're responsible. The Department of Labor doesn't care. The judge doesn't care because we're their joint employer. So how do we protect ourselves? When, there's two real fundamental ways that we can do it. One is to, follow up and track the temp agency to make sure that they're paying them properly. But that's not very efficient or realistic. We have these temp relationships and we are assuming that the other party is handling the payment issues related to that relationship, then we need to have indemnity in that contract. They're responsible for paying the employees. And if they get it wrong and we get sued because they got it wrong, but we're their joint employer, they're going to indemnify us for any losses that we suffer as a result of those mistakes that they made. Too many of these temp contracts don't have that language in there. Why? Because the contracts are written by the temp agency and it's sent to you and you sign off on it, or one of your supervisors signs off on it, and we all just move along. And that's great as long as everything works fine. But when things don't work fine and we don't have the indemnity language in that agreement that protects us, then the temp agency is just going to walk away. They've got exposure too, for sure, but they're not concerned about the impact that it's going to have on you. that indemnity agreement needs to cover your attorney's fees. It needs to cover any liquidated, in the nature of punitive damages that are imposed upon you as a result of the violation. So, I say this because, only you are going to have the knowledge and the skill set to tell that supervisor who needs temp employees but doesn't care about these issues, hey, here's what could happen if we're not careful. And because we're not going to have the ability to monitor how this temp agency actually pays our employees, these temps, we need to have this language in there. And if they won't do it, we got to go find somebody that will. And there's temp agencies out there that understand this. The really sophisticated ones know that that's part of the sale that they're making to you. They're going to build it into the price, right? And so, I say all this to say this is a significant issue in wage and hour law that I've seen kind of develop over time. A misunderstanding of what that relationship is and the ways that we can legitimately protect ourselves. So pay attention to that. All right. Moving on, the Department of Labor is working, on another big fall surprise for us, to spin us around again. In a true full circle moment for those of us that were lucky enough to go through it in 2016, we've been warned to expect a new attempt to increase the minimum salary threshold in October 22. Yay! I'm sure all of you were very excited to hear this issue pop back up again, because you can probably recall that it wasn't that long ago, really at the end of 2016, really all through President Obama's second term, we were hearing about these increases to the minimum salary threshold. And that's particularly for the Section 13A1 exemptions, the more common ones, administrative, executive, outside sales, computer employee. And as his term neared its end, it increased that threshold from 23,660 to 47,851. That was the proposal. And it would have doubled the minimum salary threshold to be classified as exempt under most of these FLSA exemptions. Now, the good news, as all of us remember, it was permanently enjoined by a federal court in 2017, of course, after most of the employers had already complied. So we didn't end up having that doubling of the minimum salary threshold. During President Trump's administration, it was increased to 35,568 and kind of a compromise of sorts. It was, we know this needs to go up. It didn't need to go up as high as the Obama administration was proposing, but let's kind of get it to a place where hopefully everyone will be fine for a while. Well, President Biden's administration was not fine. They don't believe 35,568 is sufficiently high enough to qualify as a threshold for exempt status. And so we're kind of right back where we started. And now here comes the rain again, right? We're about to go through all of this again. So what's possible when this rain returns? We know that it's scheduled to arrive in October. Some of the experts out there think the DOL is not going to be satisfied with half measures. So, there is this range that people are predicting, anywhere from back to close to President Obama's number, which, rounded is roughly $1,000 per week for the minimum salary threshold, to more than $82,000 a year. And that would be based on some national metrics for exempt employees around the country. If you recall back in 2016, when we were speaking about this regularly, the thing that I always brought up and that I think is critical to recognize is that, different parts of the country have different salaries, right? I mean, the market's different in Birmingham, Alabama than it is in, Boston, Massachusetts. And so we don't really account for that in these thresholds. And, $82,000 a year is a very different number in New York than it is in Charleston. And so we recognize that there's going to be some pushback, regardless of what the number is, but particularly if it goes as high as that. There's some other folks that believe it's going to include automatic escalators that are tied to economic metrics, kind of like the consumer price index. As inflation rises, then the minimum salary threshold will rise correspondingly. I doubt that will probably be part of it, because I think that's too complicated to enforce for the courts to authorize that. Some folks, like me, speculate that we may see an effort to eliminate the duties test altogether and replace it with the one-size-fits-all model that's based on compensation level. And what that would mean is if you make, $85,000 a year, you're exempt, period. We don't have to worry about whether you supervise the work of 2 or more employees. We don't have to worry about whether you use independent discretion and judgment in the exercise of duties related to the business. We just eliminate all that. And we say, if you make X dollars, you're exempt. If you don't make X dollars, you're non-exempt. There are a lot of ways in which this would be more efficient for everybody. Now, it would increase the number of, potentially non-exempt employees we have for sure, but it might be easier in the long run. And so there's some thought that might be the way that this goes. That'd be bad news for lawyers like me because I spend a lot of my time arguing about those issues that would go away. But it is something that, I think the business community is eventually going to have to grapple with. It's almost like the flat tax. It was popular for a while because of the ease of administration. And so, we may see some of those issues begin, and all of this is, we expect all of these things, the changing thresholds, they're going to evolve over time as jobs evolve, as compensation evolves. You think about the fact that the minimum wage has been $7.25 for almost 20 years now. It's just crazy but it's such a political issue that it doesn't change. It's so polarizing that the number has just stayed the same, even though, $7.25 20 years ago is nowhere near the same thing that $7.25 is today. Now we've talked about this already, but I'm worried about you guys. I'm worried about how we make sure that we're not the ones that end up getting the blame, right? No one is to blame, as Howard Jones sang, except you'll be blamed. You're the ones that are going to be feeling the punishment, even though you didn't commit the sin. So we've got to audit. We have to consider these salaries, determine whether or not they exceed these various possibilities that could result from the expected new threshold. I would do it now. I would do it right. It's coming. Something is going to develop in October of 2022 that's going to change this threshold. Are you paying your exempt employees across the board sufficiently that you're not concerned about whether the threshold moves to $50,000? If you aren't, then you probably should start now talking with some of your frontline leaders and anticipating what these changes might be and thinking about solutions, because it's not easy. These things take time. So if we are paying people enough, if we are confident that we're paying people over the threshold, then we move to those duties. Is the job same or has it changed? Does the job description still describe exempt duties that the employees actually perform? Ask your supervisors for examples. Make them defend their responses. Consider whether employees, the actual employee performing the job, should be interviewed as a part of the evaluation process. The supervisor may have a different understanding of what the job actually is than the employee who's, literally performing the job. And so we want to make sure that we're getting the right information. One thing always leads to another, and another possible legislative effort is an increase in the minimum wage. We were just talking about that. It still sits at $7.25. That's the federal minimum wage. Of course, a lot of us work in states where they have different standards, and some of those states even have cities and counties that have different minimum wage rates that are far above the federal level. And I tell you all this, even if you're not in a state like that, it's important to monitor it, because these changes have a tendency to become contagious. They compound. So you want to pay attention to what the climate is in the state and the city, the county where you work, and just keep an eye on it. And it could be that you believe strongly in a particular number is fair and realistic, and you want to lobby your legislature or your city council or whatever for a particular number. I say all this to say pay attention, because states are making significant departures from the federal minimum wage rates. There are some places where it's more than double the federal minimum wage rate. And you also need to know this if you have remote workers or employees that are working in those locations, because the law of the locality is going to be the one that controls. If your employee is working and you hire a worker remotely that's in California, and you are trying to pay them $7.25 an hour, you're going to have a problem. And so you need to think about those things as you potentially hire employees in locations that aren't the physical workspace that you are in now. But in the end, last bullet there, I think is the most critical. Expect all this to hit the table again. Let's start making plans now so that we don't get behind. A whole different direction for a second. I think it's important to remind everyone that child labor issues are considered the Department of Labor jurisdiction. They're under the same, Wage and Hour Laws, the Fair Labor Standards Act. And I point this out because the demand for labor, from my experience recently, has driven some employers to look into these untapped markets for workers. We want you to be careful. Looking at the slide, well, first of all, is there any industry that has better exploited effectively child labor than the Girl Scout cookie industry? I've thought about this for years. Man, that's a lot of free labor. Anyway, back to the slide. The rules limit employment in which children under age 14 and up to age 18 can be engaged. We also have a lot of state laws that govern employment of minors. The tight labor market has made these younger workers more attractive in certain industries, and I'm thinking in particular about the restaurant industry, the service industries, where it's not a dangerous job, but it requires a lot of hard work. The Department of Labor is really cracking down on this. They're focusing on this issue. If you have this as a labor model in your workplace, pay particular attention to what's going on and how these things are developing. As I've mentioned at the outset, one of the things that the pandemic and the economic disruption that it created has done is to make recruiting and hiring, retaining employees a greater challenge than ever. And so employers, we're all making more promises than ever to attract and keep these folks. And it's kind of a plug to the first full-scale in-person client appreciation seminar that Burr's done back in the Birmingham office since the pandemic. We've got one coming up soon, and we're going to devote significant attention to this issue. The fact that there have been so many changes in the way that we have to incentivize and recruit, and we're going to have some clients that are going to talk about these issues and kind of help us waddle through some of the ways that that people are making adjustments to everything that's going on. But just kind of like hit the bullets of what I've been seeing. I've seen clients that are offering 32-hour work weeks. Just sort of disrupting the work model. We've got so many, and I'm going to use the term millennials, Gen Z, the younger generation that are motivated by different things than just straight money. They want more flexibility. They want the opportunity maybe to work 2 jobs, maybe to do a 32-hour work week for you and work as a bartender on the weekend. And so employers are thinking about these, and again, this can impact how we pay these folks. I've had some that are paying 40-hour work weeks, but only requiring 32-hour weeks. These are things that we've got to kind of factor into how we calculate. Are we offering gratuitously overtime after the 32 hours that they're scheduled to work? How does that relate to the tracking of time, through overtime? Off-cycle non-discretionary bonuses, does that impact the regular wage rate? Pay equity issues for unscheduled raises to retain workers. And what I'm talking about here is this has happened, at least 3 times in the last month for me, where an employer has told me that they have offered someone a significant raise to keep them because they threatened to leave and they just couldn't afford to lose them. And that's great. You got to do what you got to do, right? But what if we have, a white male who has another job opportunity and we bump his pay up to keep him, but we've got a black female that's doing the same job who didn't threaten to leave and is still making the same amount of money. Now we have a pay equity issue. We have a potential Equal Pay Act claim. And these are things that we often don't even know about in human resources sometimes, that just gets done. And, the supervisor did what they thought they needed to do to keep the work, to keep this employee doing the job. And it creates, major problems down the line. So we want to think about that. Some of these incentive payments that can have an impact on the wage rate, things like pay for performance, shift premiums, attendance rewards, all of this stuff that potentially needs to be calculated into the base wage rate when we are calculating overtime for employees during that pay period. Do we need to go back and true up the overtime based on the revised base rate because of these types of bonuses or additional additional work that has to be done. So, the considerations that I think you guys need to be considering. Do we have any of this described in writing? What are our policies and procedures? What do employees understand and expect with regard to these promises that we're making because of this disruptive labor market? Have we accounted for the overtime issues it could create? And have we compared pay between workers in the same job classification? Has it remained equal for employees that are doing the same job? And honestly, this is the thing we don't do enough, even absent this disruptive labor market. So often, off-cycle raises or, one employee kind of takes on a little bit different responsibility. So we give them more money, but they're still in the same job class as another employee who's not making as much. Is it equal pay for the same job? And if it's not equal, why is it not? Is that based on tenure, experience, additional duties? What are the reasons? We need to be able to articulate and document what those are if employees in the same job class or category are not making the same pay. And then, as we kind of wind down, I can't speak about wage and hour law without some discussion about what I view, what I'm unquestionably is the most dangerous aspect. It's an area I've devoted a lot of my career to, and we've had some great success here recently, and that's given me a new perspective on how to defend these cases. I mentioned Carr versus AutoZone as a case study. That was a case that we handled that's publicly reported, and so I can talk a little bit about it. But we were successful in the decertification of a collective action that had potentially thousands of employees. It was based on a misclassification. And one of the things I learned as I went through that experience and with thousands of potential employees and thousands of stores all around the country is that the reality is store managers, exempt employees very often are doing different jobs from each other. They may be in the same job category and they may have the same set of rules and expectations that apply to them, but on a day-to-day basis, if they're not very good at their job and their district manager is having to tell them what to do, are they exempt? As an alternative, some of these folks, who've been doing the job for 15 years, they don't need anybody anytime to tell them what to do. And what that has meant, and one of the reasons we were successful in decertifying that case is because the idea that all of these people everywhere could legitimately be doing the same job is frankly unrealistic and absurd. It's not possible. And so, for you as a human resource professional, the lesson to learn is that, you can't expect just because you wrote down the job in a job description that's what's actually being done on the floor. And so it's important then to go back and confirm that, because these collective actions can lead to significant exposure. If you have a group of employees that are all doing theoretically the same job, you are exposed to a collective action, whether it's from off the clock or misclassification, whatever, you're exposed to that. So the things to briefly consider: what's arbitration agreements impact? Bonus and premium pay calculations, donning and doffing, pre and post shift safety health screenings, and the meal and rest period rules in certain states. We've talked a little bit about those already, but I'm going to flip back to the first bullet to just kind of, you have to consider whether or not you want arbitration agreements with these employees, because they're really impactful in defeating a motion to certify. And so, they aren't for everyone, and there are some downsides to arbitration. I think it's important that if you believe you are susceptible to these types of collective actions, that you talk to your counsel and you guys work out a strategy for whether arbitration agreements are effective for your business or not. They may not be, but I've seen too many times they've defeated motions for collective action certification on the front end because those claims have to go to individualized arbitration. Finally, just a few headache-inducing topics I wanted to briefly mention. These are the kind that make every day feel like a Blue Monday. Paid leave entitlement in some states. Are you guys paying attention to that? PTO calculations, making sure that we understand how PTO relates, when we're away from the office, whether or not we have to compensate for potential hours worked during, like, for example, a vacation. If you're working during a vacation, do I have to pay you overtime because I'm already paying you 40 hours? The answer to that question is no. I mean, it's gratuitous. PTO and wages are unrelated to each other. We start hour one for the work that you're actually performing. PTO is paid separately. But we want to think about those things. Pay transparency laws are on the rise. The inability to tell employees they can't discuss their salary with each other. Those are laws in some states, not most of the states that are within our footprint, but it's something to pay attention to. Wage fixing is an area of interest at the DOL right now. You can't talk to your competitors and say, I won't pay more than X if you won't pay more than X. Can't do that. And then the tipped employee rules, if you're in that kind of industry, those have changed a little, and I would encourage you to reach out to one of us at Burr and Foreman to help you with those. So let's, I'm gonna get into some questions now. And while this song title didn't fit into the presentation, I shoehorned it in because it's the best song of all time. One of the all-time greats, and it's how I assume that you're gonna be describing this hour to your friends and family later. It's just like Heather. All right, so let me get to some questions. I've got a couple here. Let's see. Do you see any issues with requiring an employee who has what the employer thinks is excessive OT and/or performance issues to come back to work in the office when the rest of the team works remotely? For example, could this potentially set the employer up for a discrimination claim? It could, absolutely. That's a really good question. And it's something that I've seen. It's a really good question that comes from my former associate, Megan Cox. That's fantastic, Megan. It's always great when our alumni come to our presentation, so I appreciate that. But yeah, no, absolutely. It can create the potential for a discrimination claim, and I think and Megan, of course, knows this, but the important thing here is to document those performance issues and the reasons why this employee is not similarly situated to the others because of these, because of this excessive overtime, because of these performance issues that we've documented. We simply believe that this is not working out as remote work. And, to the extent that they made a discrimination claim, they wouldn't be similarly situated to the employees that aren't having excessive overtime and performance issues. Now, like everything else, there could be some subjectivity here. The employer thinks it's excessive overtime. The employer thinks that there are performance issues. We want to be able to articulate what those are and what the bases for those concerns about excessive overtime are, because we want to be able to demonstrate why the employees are not similarly situated to each other. Otherwise, the employee is going to have a pretty good discrimination claim that the remote work, the other employees are allowed to work remotely and I'm not. So we need to set up exactly why we've made that decision. And that's the only question that came through the Q&A while I was talking. I did have one other question that I didn't get to in the presentation, and that's a pretty niche question, but it's about state and local governments and whether there are any new rules that are specifically applicable to those. And the answer is no. Pretty simply, right now there aren't any that are specifically applicable to state and local governments. Of course, if you're in a state and local government, there are some ways in which the Fair Labor Standards Act applies differently to you. You can offer comp time instead of overtime pay in certain instances. But other than the fact that some of these changes are generally applicable to everyone and to you, I don't see anything that is specifically applicable to state and local government that's going to change any of the rules that you guys have to follow. So I think all is good there. All right, it's been an hour and 5 minutes. I appreciate all of you who stuck it out with me today. I hope that you were able to get some valuable information. And again, I remind you, we do these morning shows on a regular basis. Please, look for those emails and attend when you can. I think they provide some valuable information. If you're close enough, we'd love to have you at the Birmingham Client Appreciation Seminar that's going to be coming up in September. So look for information about that. If you haven't received it, feel free to reach out if you're interested. We're also going to be doing some similar presentations in other markets, Nashville, Mobile, Atlanta. The Carolinas are doing those consistently as well. So look for that information. But again, I appreciate you guys being here this morning. Thanks for taking the time to learn a little bit about wage and hour law with me. Reach out. Feel free to reach out if there's some questions that you would have liked to have answered that I either didn't get to or that you didn't type in. But again, I hope you guys have a great day. And also, I'll finish with, I'm happy to provide this in a playlist format to anyone who asks. I didn't, these are all 16 bangers. These are not just songs I picked because of the title. They're great songs. So I encourage you all to make a playlist and listen to it tomorrow night out on your patio. Thanks again, everybody.